It's nice to meet you again. Okay, so today we are continuing with our presentation. So today we are going to do workplace disciplinary procedure. So first of all, maybe we should ask ourselves, what is a disciplinary hearing? Maybe briefly we can say a disciplinary hearing is a quasi-judicial inquiry. It is designed to prosecute an employee on charges of misconduct. For example, an employer may discipline an employee when an employee is suspected or is accused of committing a workplace misconduct. So it is important to note these persons that are involved in a disciplinary inquiry. So firstly, you will have a complainant. Someone will come maybe to the management or to an HR official, and this person will bring a complaint, he will lodge a complaint or a grievance against another employee. So this does not need to be an employee. It can be a customer, it can be an external party, it can be an auditor, it can be a security officer, it can be a contractor. Anyone can be a complainant. In the context of a workplace, the person will normally lodge a complaint or a grievance against an employee. So once a complaint has been lodged by a complainant, so someone will investigate. It can be either human resources personnel, it can be a manager or a senior employee who will investigate the allegations. So this person will take statements, he will collect evidence, and if necessary, he will write a report. So another thing that we need to take note of is a person called an initiator. So now a complaint has been lodged and it has been investigated, and we have found that there are grounds for charging, or there are grounds for a dismissal. So now, before a disciplinary hearing starts, an initiator, someone who will institute the formal charges against an accused employee, and he does this on behalf of his or her employer or on behalf of the company. So an initiator is normally an in-house personnel, is normally your manager, or it can be an external party. So normally an investigator is normally also an initiator, because it's a person who's aware, or a person who's got knowledge of what has happened. So, and then you have what we call an accused employee, or sometimes you can even call it an affected employee. So this is an employee who has been formally charged. So you have been formally charged, you've been served with a summons or a notice to attend a disciplinary hearing. So after you've been served, so now we call you are an accused employee. So please note that some of the words have been borrowed from a criminal inquiry, but a workplace inquiry is totally different from a criminal inquiry. So let's just not confuse the two. Ne? And also, when I'm using these words, I'm using it in a more general sense, not in a way of blaming or in a criminal sense. I'm using the plain reading of a word. When I say accuse, it means that you've been accused of something. It has nothing to do with any criminal element. So I would like us to look at these words from a general perspective, not from the eyes of a criminal investigation, like the plain reading of an English word. What does accuse mean? So I would like us to look at these words from that perspective. So normally, this accused employee will have an employee representative, someone who's going to represent. Remember, in a workplace, we normally, legal practitioners are not allowed. So normally an employee will choose a trade union representative to represent him in the disciplinary hearing, or else he will use a fellow employee to represent him. So remember, the initiator represents the employer. Then the employee will also have his own representative, normally a trade union or a shop steward. So, and then we have a person called a disciplinary chairperson. So the chairperson of a disciplinary is normally an independent, or supposed to be an independent person. He is appointed by the employer to facilitate and to arbitrate a disciplinary hearing. So the chairperson can be either an in-house personnel from another department. For example, if you are in the finance department, maybe they can choose a manager from a different department, maybe from an HR department, or maybe from a legal department, from a department that is different from the department that you are in, so that that person can be more independent. So, or else a company can hire someone who has an experience in labor law, an attorney, human resource professional from outside to come and facilitate the hearing. So one thing what we have to look at is that when you talk about a disciplinary hearing, there's something important in terms of the Labor Relations Act. This is called Schedule 8, the Code of Good Practice. It's normally at the bottom of your Labor Relations Act. And what this code states is that normally an employer should conduct an investigation to determine whether there are grounds for a dismissal. So before this disciplinary hearing is initiated, before it even starts, after a complaint has already said that there's an investigator. So there must be an inquiry, there must be an internal investigation to determine that are there grounds, is this complaint valid? Is there a prima facie evidence to prove that this person needs to be charged formally? Remember, sometimes people make accusations because they don't like you. Remember, people sometimes they can make accusations without really, based on feelings, without really understanding what the law says. Or because you feel like someone is a threat to you, or you don't like a person, or you're trying to revenge them by making accusations against a person. Those allegations need to be investigated to make sure that indeed they are valid. Indeed, we can formally charge this person. Remember, the person that you are putting accusations or allegations against, that person also has rights. That person also needs to be protected. We don't want to subject that person to a disciplinary hearing unfairly. So what is important is that an investigator should be, ideally, the investigator should be the initiator. I've already mentioned this. However, in some cases, the investigator does not need to be an initiator. So the reason I'm mentioning this disciplinary investigation is important because not only for that, it's also important for the process, to ensure that the process is biased. So in the investigations or disciplinary that I'm involved in, I always ask, what are the processes that have happened? Was there an investigation? Where is the evidence? Where is the investigation report? Because remember, sometimes employers also commit unfair practices or unethical practices. You find that there were 5 witnesses, and then the employer will only choose those witnesses that he believes that will speak in his favor, or will support the employer's version. You see, for example, if they are black and white people, and the employer and the management is a black person, will normally, sometimes they will only take statements from the black employees. So that is unethical. They should take all the statements from all the witnesses and assess the investigator should assess that evidence objectively. So it's very important to look into the investigation. How was it conducted? How many witnesses? When was it conducted? So another case that I was involved in, a customer who was also investigated gave a statement, and this statement was not in support of the employer's version. And the attorneys were initiators. In this case, the company hired external attorneys, and they hide from me that statement from a customer because simply it was not supporting their version. It was supporting the employee's version. So there are those unethical practices. That's why you need to make sure that you understand, you research, and you ask the employer, was there an investigation? If it was not done, why was it not done? what is the evidence? So sometimes you find that if they want to charge you, for example, in most of workplaces are more advanced. You find that the records are kept in an Excel spreadsheet or in a system. When they want to charge you, sometimes you find that they only filter your name, and they print it out and say, on this particular day maybe you came late, or you didn't report for duty. They only filter your name. But if you look at the spreadsheet on it as a whole, you find that there are many other people who committed the same alleged offense. So it's very important to ask those kind of information, like give me all the spreadsheet. How did other people perform? Why you only selected this person? So you can use that as part of your defense during the disciplinary hearing, and say there are pre-disciplinary irregularities. You're supporting maybe your defense if part of your defense is that the employer was biased or was inconsistent in applying a disciplinary rule. So you can use that information. So this is very important to understand those pre-disciplinary investigations, and it will help you to support your version. So remember, sometimes it's not very useful. It's not a very strong defense on its own, because the employer can still argue that you had enough time to bring that evidence into the disciplinary hearing. So even if there were gaps in the disciplinary in the investigation, you still had a chance to bring it when a disciplinary hearing started. See? So it's not a very strong defense. However, if it's part of your overall defense, that can give you more credits to what you are claiming. So it's very important to understand that pre-disciplinary process. So the other thing that we have to do now, after the disciplinary hearing, remember, there will be a notice to attend a disciplinary hearing. After the investigation, there will be a notice now that you're supposed to attend the disciplinary hearing. So when you have been given this notice, you will attend a disciplinary hearing. What is important in a disciplinary hearing is that the employer carries the burden of proof. So, and the person who's actually arbitrating or adjudicating the disciplinary hearing, the chairperson, there are two things that he must look at to judge if the disciplinary is fair. And this is also the two things that the employer will emphasize. This is the truth, and also the things that you will also, as an employee, emphasize is that the disciplinary, it must be for a fair reasons. Well, this is what we call substantive fairness. The dismissal will be fair if there are fair reasons for a dismissal. So, follow a fair procedure, which means that they must give you time to prepare. They must tell you of the charges. They must give you a notice of the charges. They must give you time to prepare. They must give you evidence. The chairperson must not be biased. So the process itself must also be fair. They must even give you time to have someone, legal representative or union representative. So these are important. The procedure part is important. So it's what we call a procedural fairness. So what is also mentioned in terms of the Labor Relations Act, Section 188, is that someone who's chairing a disciplinary inquiry, you must take into account the Labor Relations Act, Schedule 8. And I want us to look into it so that we can understand what does Schedule 8 Code of Good Practice mean, or what does it say